So this is our group members. We have five group members for this presentation. And first member is Muhammad Amir Farhan bin Muhammad Nawawi. Second member is Muhammad Faiz Hakimi bin Muhammad Noor. Third member is Muhammad Arik Al-Haki Aufa bin Abdul Razak. The fourth member is Muhammad Akmal Haikal bin Muhammad Saimi. And member number five, which is me, Muhammad Aiman Mukmin bin Zainuddin. Alright, before we go through the slide presentation, I'm going to introduce to you guys to this case first. Okay, this report examines the legal disputes between Katapang Trading Co. and Jambal Steel Berhad over 150 million ringgit supply agreement for semiconductor components intended for Malaysia's electric vehicle industry. The case involved key issues such as contract formation, with ambiguities in term and procedural irregularities in the signing, as well as a breach of contract due to a non-delivery and damages from a factory fire. This analysis will apply the ILAT method to evaluate the legal aspect of the dispute, including contract validity, the enforceability of a term, and available remedies under Malaysian business law. The objective is to assess the legal standing of both parties and suggest appropriate legal solution based on the fact of the case.
The first issue that we found from the question is from paragraph 6, which is about caution. So for the issue, whether the contract between Ketapang Trading Co. and Jembal as Sendirian Berhad is legally valid or voidable. There is possible element of caution involved in forming the contract. The CEO of Ketapang Trading Co. was forced to enter into the contract. The caution came through a trade made via an anonymous email, and the trade may render the contract voidable under Malaysian contract law. For the law, under Section 15 of the Contract Act 1950, caution involves committing or threatening to commit any act forbidden by penal code. Involves forcing someone into contract against their will using threats or unlawful actions. A contract made under caution is voidable at the option of the party whose consent was obtained through caution. Case reference Kanhaya Lal versus the National Bank of India, which is a case involving property being taken away. It highlights the application of contract law in relation to caution. For the application, 2 days before the contract signing, the CEO of Ketapang Trading Co. received an anonymous email with compromising photos. The email threatened to release the photos to the media unless the contract with Jembal Sendirian Berhad was signed immediately. The trade was made just before the contract signing, which pressured the CEO into agreeing quickly without real choice. The CEO reported the incident 6 months after the contract was executed, which may suggest he accepted or ratified the contract. Despite the delay, the contract can still be cancelled if the CEO can prove he was forced to agree and did not consent freely. For the conclusion, based on the fact and the law under Section 15 of Contract Act 1950, the contract can be cancelled because of caution. The threat to the CEO was illegal and clearly meant to force him to sign the agreement. The fact that he was forced to sign the agreement gives the right to the CEO of Ketapang Trading Co. to cancel the contract.
Okay, so I will continue with the next issue. It is a breach of contract. Okay, for the issue, Jembal Sendirian Berhad failed to deliver 50,000 microprocessor on time, and did Jembal breach the contract by failing to deliver, causing substantial losses to Ketapang Trading Co. and is Jembal relief of liability under the force majeure clause due to fire caused by lightning and enforceability of the liquidated damages clauses and its implication. Okay, then for law, under Malaysian contract law, which occurs when one party defaults. This is non-delivery of goods and sale of goods at 1957 and Contract Act 1950. It is provide remedies for breach. Example, damages for financial loss. 10 force majeure clause only applicable if included in the contract of properly invoked, and liquidated damages can be enforced if Jembal defaults. Okay, then for application, Jembal failed to deliver on time, breaching the contract. Force majeure may not apply as Jembal didn't properly invoke it or notify Ketapang, yang Ketapang incurred 7.9 million in liquidated damages and lost a distribution contract. And Ketapang can recover damages without proving actual loss due to liquidated damages clause. And in conclusion, Jabal breached the contract. Enforcement measure doesn't apply due to failure to notify and invoke the clause. Ketapang entitled to 7.9 million liquidated damages and additional compensatory damages for financial and reputational loss.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Kamal Haikal bin Muhammad Suhaimi. My matrix number is S71470. Alright, so I will be presenting about one of the major legal issues in this case, which is mispresentation. Alright, so the case between Ketapang Trading Company and Jambal Seri Berhad under Malaysia law, mispresentation is defined under Section 18 of the Contracts Act 1950. It happens when a false assessment of facts made by one party and the assessment causes the other party to enter into a contract. So there are three major types of mispresentation, which is fraudulent mispresentation, and the second is innocent mispresentation, and the other one is client mispresentation. Right, so in this case, Jembal Sdn Bhd made a specific claim during negotiation. They state that their semiconductor component could withstand extreme temperature ranging from -40 to +125 degrees Celsius. This was an important condition because for Ketapang, their product are going to be used in Malaysia tropical climate under the Malaysia EV Revolution 2030 initiative. Naturally, Ketapang rely on this information when deciding to enter into a high value contract. However, it was later revealed that Jembal's component had only been tested up to a much narrower range, which is from -20 to +101 degrees Celsius. There were no documents to support the wider claim. Even worse, a handwritten note from junior engineers inside Jembal's own test report admitted that further in testing was postponed because of budget constraints and pressure to meet Ketapang's deadline. This shows that Jembal either knew the statement was untested or at least, or at very least, failed to confirm it properly. Okay, because the statement was made as a fact during negotiation, and Ketapang clearly rely on this information when signing the contract, the agreement. The situation falls within the legal definition of mispresentation. Specifically, it would be considered negligent mispresentation since Jambal made a technical claim without a proper evidence. And if the court finds the Jambal knew the statement was false, it could even be considered fraudulent. So in conclusion, Jembal's false technical specification about the product's temperature range amounts to mispresentation under Section 18 of the Contracts Act. This gives Ketapang the legal right to either resign the contract or claim damage, depending on how serious the court views the presentation. Alright, that's all. Thank you.
So, issue number 4 of this case is contract validation. So, as we can see in the issue, it is whether the contract between Ketapang Trading Co. and Jebel Sdn Bhd is legally valid and enforceable under Malaysian law. The contract was signed by the regional operation director who lacked required authority under Ketapang's internal governance protocols. It is raised a legal concerns about agency and authority in contract law. And the key question that raised in this issue is, did the director have actual or apparent authority to bind the company? And if not, is the contract invalid or voidable? The outcome depends on interpretation under the Contract Act 1950 and whether the Act can be ratified or excused by law. If we see on the law point of view of this issue, we can see on the section 10(1) is stated that a contract is valid if made with free consent by competent parties for the full consideration and object. Then we can see on section 140, an agent cannot bind the principal if acting beyond the authority. And also on section 149, which is a principal is not bound unless the ratified actions done beyond authority. Also, don't forget on the section 188 that differentiate between actual authority, which is expressed and implied, and apparent authority inferred from conduct of position. Alright, case example that we can relate with the case is case of Tan Cheng Han versus Public Bank Berhad in 2004. In this case, Malaysian court held that internal protocol must be followed and contract made without proper authority may be unenforceable. So the application of this issue that we can apply from the law that we explained earlier is the regional operation director did not have the authority to sign contracts over 30 million ringgit because it violates the law of section 140 of Contract Act 1950, and the board didn't approve the contract before or after signing. Jembal Sdn Bhd might think that he had a brand authority because he had a high position and signed it at a big event, which is a meeting conference. However, without formal ratification, Ketapang Ketapang could argue the contract is not legally binding. Okay, the conclusion for this issue is the contract is likely not valid because the regional operation director had no authority and the board did not approve the deal later. This goes against Section 140 and 149 of the Contract Act 1950. Unless Jembal Sdn Bhd can prove the director had upon authority, the court may rule in favour of Ketapang Trading Co. So, the contract could be unenforceable or voidable. Unenforceable. Unenforceable.
The next one is issue 5. Remedies are available for breach of contract. The issue is, as a result of Jembal Sdn Bhd's breach of contract, which led to significant financial loss, reputational harm, and business interruption, what remedies of breach of contract are available to Ketapang Trading Co. under Malaysian Contract Act 1915? So, the law we use is Section 7(4) Contract Act 1915, Compensation for Direct and Foreseeable Loss, Section 7(5)(c)(a) 1915, Right to claim liquidated damage, which is pre-agreed sum, and the Section 18 Contract Act 1915, Rescission available for misrepresentation. After that, application: 7.9 million liquidated damage recoverable under Section 7(5). Loss of 25 million ringgit contract equals to foreseeable consequential loss under the section of 7(4). Reputational damage equal to consequential loss. Ketapang's brand was key to securing national contracts, and if Jembal misrepresented product specs, rescission may apply, but delay in reporting may weaken claim. And the conclusion for this issue is Ketapang can claim liquidated damage, which is 7.9 million, consequential damage, which is 25 million ringgit contract, and plus reputational harm. Rescission is if misrepresentation is proven. These remedies reflect the right to be compensated fairly under Malaysian contract law. The conclusion is, overall, this case highlights the importance of adhering to corporate governance protocols, ensuring the accuracy of statements during contract negotiations, and taking timely action when legal breaches or threats arise. It also demonstrates how the principles of Malaysian contract law, particularly under the Contract Act 1915 and Sale of Goods Act 1957, are applied to protect the rights and interests of parties in high-value commercial agreements. Thank you.